Well, let's turn to elections. Obviously, elections are a very interesting subject in Florida. We've had national controversies going back to the election of 1876, the Hayes-Tilden election, and most people will remember the drama and importance of the election of 2000, both elections in which Florida played very significant roles, and courts played very significant roles. And so elections can be a very interesting topic. Constitutionally, however, there are not many things here that are inherently of interest. There are a couple of things, and there are several things that I hope you'll think about in terms of future Constitution revision. Do we have the right system in our Constitution? And if not, what changes might we make? And I'd like to have some discussion, in-class discussion, about that subject as well. Well, let's go. Our objectives here are really to understand the Florida Constitution provisions governing voting rights in elections, to understand these term limit provisions in Florida. It can be quite confusing, and to contemplate a different regime for elections. Regulation of elections. Elections shall be by secret vote, by direct vote. That sounds simple enough. At one point, some states, including Georgia, had a county unit system that looked like the federal electoral system, but it's clear in Florida, under the U.S. Constitution first, but also under quite explicitly under the Florida Constitution, it has to be a direct vote, and it has to be a secret vote. The Constitution calls for a plurality of votes cast to be the basis for election. In a minute, I want to pause and think further about that. And then a provision that protects minor parties, which is quite remarkable that this appears in the Constitution. So let's ask the question, what happens when you have a plurality of votes cast determining an election? First of all, let's go to the primaries. When you have primaries, you now have, in the state today in 2014, you have a two-party system. So you now are going to elect on the basis of a plurality vote. That means that in each party, the candidate with the largest number of votes is going to be the nominee. And when you get to the general election, between all the candidates, major party candidates and minor party candidates, you can have the plurality. Florida at one time had a runoff system, and the runoff system would require, at the primary level, a runoff between the top two candidates. And that if you go back in time and find elections that brought us such governors as Reuben Askew and Bob Grimm, Lawton Childs, you'd find that they were elected through that kind of primary system. Sadly, we've gone to this system of allowing a plurality of votes cast. So it is now go back and let's look at that. Look at this. General election shall be determined by a plurality of votes cast. So it's a constitutional provision. And my question is that a good system? Are there alternatives? And one of the alternatives I will ask you to look at is the alternative of having an open election system. California has such an open election system, and the argument there is that heavy partisanship tends to disappear from the system once you have everybody allowed to vote in the general election, and in the and then in the primaries, you may or may not have open primaries, but having at least an open general election makes an awful lot of sense to me. Electors, we've now defined them in ways that, remember, historically, we did not define them. Every person who's 18 years of age and a permanent resident shall be an elector. An oath for electors. A disqualification. Again, this disqualification relating to felony can be removed by action of the cabinet, as we saw as we look back at Article 4. And so a removal of that disability through felony conviction can be achieved through cabinet action, and that the restoration of voting rights also restores the right to qualify for office. Now, Article 6, Section 4, term limits. Terrible, terrible idea. One that really has changed the culture of the Florida legislature. But look at this list of people. No person may appear on the ballot for re-election to any of the following offices: Florida Representative, Florida Senator, Lieutenant Governor, Cabinet Officers, U.S. Representative from Florida, or U.S. Senator from Florida. Now, it should be apparent to you that this provision of the Florida Constitution is unconstitutional. The Florida Constitution may not set limits or set qualifications for people who are going to serve in federal office. That's the function of the federal Constitution. And we have decision in U.S. term limits case in which the U.S. Supreme Court has struck down provisions relating to the term limits for congressmen and senators. And yet this provision rests in the Florida Constitution. At the time it was adopted, at the time it was being proposed, the matter went before the Florida Supreme Court, and Florida Supreme Court issued an opinion and allowed this measure to go on the ballot. And at that time, Justice Overton said essentially to allow this measure to go on the ballot is a fraud on the people, because there's so much in this provision that relates to term limits for federal officers, and the state constitution may not set qualifications for federal officers. So Ben Overton was right, but U.S. term limits versus Thornton had not yet been decided, and so the Florida Supreme Court let this go forward, and sadly we now have term limits for legislators. But it can produce some really strange results. Let's go through an example. Let's say following reapportionment in 2012, 2 senators are elected for their first term. Senator Abel is elected for 4 years. Senator Blackwell elected for 2 years. So now, 4 years later, Senator Abel is elected for another 4 years. He now, at the end of that time, will have served 8 years. Senator Blackwell is elected originally for 2 years. And at the end of that time, now they're under staggered terms, he stands for election at the general election 2 years after his term starts. So his term now is 2 years. And at his election, 2 years, he stands for a 4-year term. And he's now now served in office for 6 years. So going back to the language of the Constitution, the section says that any person who has served in office for 8 years may not go on the ballot. Well, Senator Blackwell has not served for 8 years. So in his election, his second election, assuming he was elected to the 2-year term and then to the follow-up 4-year term, he now may be elected to another 4-year term. And he ultimately serves for 10 years, not for 8. So we can get some strange results as you go through the analysis of how these sections actually work. provision in the Constitution for primary, general, and special elections. Again, keep thinking about all the parts of the Constitution where you have a vacancy in office, for an elected office. You should have a special election. But remember, the appointment power of the governor plays in here as well. So governor may appoint for a period of time, and then a special election be held. Remember that the governor has no authority to make appointments to the legislature. That's one area where the governor's appointment power does not reach. Again, a provision of the Florida Constitution that probably is totally useless. If this were not here, the Florida legislature would have this authority, but obviously there is regulation of local elections, campaign spending, a declaration of Florida policy. The public financing of elections is a subject that we might want to talk about a little bit in class, but this declaration of public policy is one that can be ignored by the legislature. And again, with such provisions of the Constitution, you need to always think about whether or not it's enforceable. Will a court enter an order of some kind enforcing provision? And if not, you may doubt the effectiveness of such a provision. Well, that's a pretty short presentation on Article 6. It can be a fascinating topic, but constitutionally it's not all that complex, and it's in the application and the potential reform of elections in Florida that I think you'll find the greatest interest. Thank you so much.